I am with my wife whose leg is injured. I am with my child who I do not know whether is going to survive or not. I may not be in a fit condition to disclose too many things. Now, what will happen in a criminal trial is the witness will come. The witness will state what he believes is the truth or what he is given an original representation to the police.
Here he said कि गाड़ी चालक द्वारा गाड़ी भेड़ने के बाद पुनः जानते हुए कि मेरा बच्चा उसकी गाड़ी के नीचे और मेरे द्वारा उससे हाथ जोड़कर उसे गाड़ी आगे न बढ़ाने की प्रार्थना की, किंतु गाड़ी चालक को कार में बैठी महिला द्वारा कहा गया कि अगर ये लोग बच गए तो हम फंस जाएंगे और हम सभी के ऊपर गाड़ी चलाने का बोलते हुए दोबारा जानबूझकर हत्या करने के आशय से मेरे बच्चे के ऊपर दोबारा गाड़ी चलाई गई, उसी की हत्या हो गई और मुझे और मेरी पत्नी को के ऊपर गाड़ी चले गए. So
I just give what is our grievance to minors. Now, what we say is that on the date of incident itself, what has happened is before minors. They came at the hospital where I took my wife and my child, which was close by from there, and they recorded a Dehati Nalsi. That was
recorded a
Dehati Nalish. Zero FIR. Now, this Dehati Nalsi was recorded, my lords, and they registered an FIR at about 5 o'clock in the morning. They never gave us a copy of this FIR. We moved a representation to the concerned station house officer, CSP, and of course the SP on the next day, but to the CSP and station house officer of that very day, claiming that they have supplied us a copy of the FIR only at about 3:30 in the afternoon, though it was registered at 5 o'clock in the morning and we've been asking for it. And secondly, the narration which is given by us, that does not find place in the FIR. If my lords are so kind enough to see, in the writ, the narration was there, but what they do is they dilute the narrations to some extent, and I'll point out exactly what.
That I can't say right now because we have to see from the records.
No, the Dehati Nalsi itself, what they recorded in the Dehati Nalsi later on was produced in the FIR, my lords. I am in the hospital. Now, there are 2 or 3 things I'll just point out before my lords. That, of course, even the Dehati Nalsi is an understandable document. It's not an encyclopedia. They cover a cognizable offense. That's fine. Our grievance is, my lords, with thereafter what they do in the form of the statements. Now, if my lords will just see P1 to the writ petition, that is on page 16 of the writ petitions record. I'll just point out 2 things. One thing is completely omitted from the Dehati Nalsi and the 161, which is there in my representation given to the police on the date of registration of FIR. Had that a representation of mine been belated, I would have understood. But my representation to the police is given on the date of registration of FIR, in which I say I was able to stand up and I pleaded with folded arms with the accused person, please stop. And he did not. That gives me an opportunity in the facts of the case to identify the accused person and not only limit myself to the trial of this was the offending vehicle. That the police does not have in the FIR, that the police does not have in the statements. Now, I assume not in the FIR. Because I will be in a panic situation, the FIR may not disclose so many facts, the law is settled on that, matters. But in the 161 statements, when I am giving a representation stating exactly that fact, that I was able to stand up and saw the evidence. Beg your pardon, Malaz? Dehati Nalsi would most certainly be signed. I don't much dispute the Dehati Nalsi. Malaz will bear with me. I am Malaz with my wife whose leg is injured. I am with my child who I do not know whether is going to survive or not. I may not be in a fit condition to disclose too many things. But
anything which you have not stated in the Dehati Nalisi.
Yes.
Subsequently, you will state in
this statement
by some representation.
Yes.
That will give benefit to the accused.
No, Malaz. That, of course, that is a subject matter of appreciation for the trial.
This will amount to material omission in your Dehati Nalisi.
Malaz, may I most humbly submit? A Dehati Nalsi, which is otherwise an FIR, the law is well settled on that. The only requirement it has is to disclose a cognizable offense. No,
identify.
That will be, Malaz, for the trial court to decide whether at the time of recording the Dehati Nalsi, the fact that I was not able to stand up, whether it amounts to a material omission or not. My point before my lords is
depose all the incident before the trial court.
That's the difficulty now, Malaz. What will happen in a criminal trial is right now. If my lords will see the 161 statement, I am just pressing if my lords may see the 161 statement.
You may be permitted to depose as per your representation, as per your complaint dated 6/11/2024. Trial court will consider it the evidentiary value of that deposition. No one can stop you in giving a statement.
There's just one proposition I'll put before my lords. Now, what will happen, Malaz, in a criminal trial is the witness will come. The witness will state what he believes is the truth or what he is given an original representation to the police. My job, if I was appearing for the defense, was rather simple. I'll just take his 161 statement, which the police claims has been recorded on the same day. I'll put it to him. Have you stated all this to in that 161 statement? He'll say no. That would profit the accused, my lords, great.
That benefit will be always there with the accused in this case.
Yes. Now the difficulty is, my lords, when I say
several omissions and contradictions in this statement.
What I will just humbly submit for, my lords, I'm probably not able to put myself across with a lot of clarity.
In this case,
I want, my lords, that a direction be given to the police, not for any other purpose of a reinvestigation in the whole sense, but my 161 statements, as I want to give them, be recorded, be placed before the concerned trial court, preferably under 173(8). They have that jurisdiction.
you know, if the police will record the 161 statement at this stage, again that will give a benefit to the accused.
My lords, I have an explanation. I came up in a writ petition. It was my lords' order.
Instead of that, you should make a prayer that your this second day's report,
my lords,
complaint,
my lords,
be taken on record. So that will give
that would subserve.
Explain the things that at the time of stating the Dehati Nali, was in such a condition.
I would bow down to that.
Therefore, some facts could not be mentioned there.
I would
immediately thereafter, next day, I filed a written complaint before the authorities, police authorities.
Then my lords may
in
just
that situation be in a better position.
I presume my lords' advice is well founded. My submission is, if my lords would permit me to have this document, I have the original with the seal. My lords may permit me to have this exhibited before the trial court during my examination in chief, and the trial court be directed to consider this as evidence and deal with it accordingly.
Even my lord,
Instead of that, we
issue notice. Yes.
what I'm saying, my honorable, the Red Court has given them the liberty.
156(3).
it is for what purpose? File is not registered under 154.
No,
We registered file
for further investigation under section.
stages there.
We'll
His grievance is the document to be taken on record. You make a statement, this will be considered by the trial court. That's the end of the matter.
but we'll respond to that.
When he
Not
submitted that
respond. We want
complaint,
the IO here. Who's the concerned IO?
My lord,
7. 7 is the IO.
my lord, in the case of if the complainant want to produce the document as per the judgment passed in the Sakri Vasoos case,
So,
he can.
where is the original of this document? Where is the original of this document? In your records with the IO. He can't produce it.
My lord,
It should be part of the case diary. Produce the case diary. Show
we'll,
that it's
we'll
not.
produce the case diary.
You are appearing in this matter.
He was
to point this out.
the document filed by the witness or complainant, the evidentiary value of the document will be different.
Yes.
And he submitted a complaint before the higher police authorities in respect of the same crime, and it must be the part of the case diary.
Yes.
And ought to have been filed along with the charge sheet.
Yes.
If the IO has omitted to file along with the charge sheet, IO is empowered to file under section 173(8).
Yes.
And the evidentiary value of that document will be different in that prosecution case filed by the prosecution agents. Otherwise, it will be treated as a private document filed by the complainant.
that's what.
It should be a document filed by the prosecution, relied by the prosecution.
This is what they want.
So then the complainants will be able
Because my
to
letter friend was there before the Honorable Red Court while addressing.
The annexure B1 of the initial petition, my lords, his complaint is there, my lords, and he has never took the any named person, my lords. My lords may just see the complaint, my lord, that he has filed on dated 7/1/24, my lords. That is on page 16 of the initial WP, my lords.
Yes.
There is,
निवेदन है कि मैं सौरभ अग्रवाल स्वयं सो my lords, रात्रि अपनी
But why this copy of this complaint has not been filed along with charge sheet? What was the reason? Whether it was not related with the crime?
his contention has been taken in the FIR, my lords.
Not all the contention. He is more or less
He has
interested.
not
More or
ever
less
taken the
interested
name
in
of
this
the
thing. Here he said कि गाड़ी चालक द्वारा गाड़ी फेंकने के बाद
जी।
पुनः जानते हुए कि मेरा बच्चा उसकी गाड़ी के नीचे और मेरे द्वारा उससे हाथ जोड़कर उसे गाड़ी आगे न बढ़ाने की प्रार्थना की, किंतु गाड़ी चालक को कार में बैठी महिला द्वारा कहा गया कि अगर ये लोग बच गए तो हम फंस जाएंगे और हम सभी के ऊपर गाड़ी चलाएगा बोलते हुए दोबारा जानबूझकर हत्या करने के आशय से मेरे बच्चे के ऊपर दोबारा गाड़ी चलाई गई, उसी की हत्या हो गई और मुझे और मेरी पत्नी को के ऊपर गाड़ी चले गए. So these lines are not there in the 161. इस लाइन पे इन्वेस्टिगेशन भी नहीं है.
But in the FIR, my lord, it is there, my lord.
बताया कहाँ FIR में लिखा
My lords, on page 36 of the
क्या लिखा है?
married on the 12th
Yes,
paragraph of-
सेम उतना ही बता दीजिए
Same
जहाँ
matter has
कहा कि मैंने हाथ जोड़कर
My
निवेदन
lord,
किया.
the same matter has been taken under the cognizance of what he has said in the complaint has been taken on, my lords. After that, my lords, his name has been came to,
Name, we are not concerned with the name.
my lords. That's the main, my lords.
Even the issue is that he informed to the car driver
My lord.
and there was an occasion to him to see who was driving the car.
Yes.
That is not there.
Even this.
Test identification parade भी नहीं हुई.
Yes.
Only on the basis of the ownership of the vehicle you have implicated him. So he will get benefit of that.
Honorable Council, the respondent state is directed to produce the case diary. The respondent on the next date of hearing, respondent number 7.
May I see?
But in the charge sheet, my lord,
All right, re-notify on so and so on which date the investigating officer shall be personally present along with the case diary.
My, that will permit. Only one thing what I would like to point out, my lord. I'm not defending, but the particulars which it come in the charge sheet, my lord. May kindly see at page number 29, my lords. The